Hi, I'm James Crowson with Crowson Law Group. I'd like to take a few moments to talk with you about your deposition, what it is, and what you can expect. A deposition is an opportunity for the other attorney to ask you questions under oath in front of a court reporter. Typically, the deposition will be videotaped. Everything that everyone says will be taken down by a court reporter and put into a written record. So there will be a written record of everything that is said at the deposition. It's important that we're very careful in what we say and how we answer questions. And you can expect that you will hear about the deposition at trial if you say something different than what you say at the deposition later at the trial. There are two purposes for depositions. As I say, it is an opportunity for the other attorney to talk with you about your case and about you. It's called a discovery deposition for that reason. It's just what it sounds like. They're going to ask you questions and they're going to discover about your history and about you as a person and what kind of witness you'll be at trial. It's also called an impeachment deposition, which means that they can use it later if you say something different at trial under oath than you say at the deposition under oath. They will go to that part of the deposition and they will go over it again in front of the jury and talk with you about how your answer changed and why your answer changed. And of course, later in closing argument, they can suggest why you might have changed your answer. So it's important, really, that when you give your answers at your deposition, that you're sure that your answers are truthful and complete, and that's how you'll answer if you're asked the same question at trial. The easiest way to keep up with your story, of course, is to tell the truth. We're bringing this case and we have a good solid case, or we wouldn't be bringing it. There's no need to exaggerate. There's no need to embellish. There's no need certainly to lie about anything about this case. You can tell the truth always and you'll be able to keep your story straight. When it comes to how you are to answer questions at a deposition, I think you need to be very careful, first of all, to listen to what the attorney is asking. Now remember, your attorney will be there with you every step of the way, and if you have any questions at any time, you can stop the proceedings. If you want to talk to your attorney and ask a question about anything that's going on with the deposition, you can do that. If you need to take a break, you're allowed to do that as well. A lot of the defense attorneys will say, I don't mind you taking a break or talking to your attorney as long as you answer the question that I have asked you before you go on break. And what you need to know is that is a personal preference and not a rule. If you need to take a break and ask a question before you answer the question that's on the table, then you do that. There's nothing wrong with doing that. When you're answering questions, you need to really listen carefully to what the question is and only answer that question. A lot of times people are under pressure in a deposition and they have a compulsion. They want to get everything out right away as soon as it's asked. And I've sat there with people in depositions, my clients, and I've told them this very thing. And as soon as they're asked their name, they'll talk for 25 minutes about the weather or whatever. You've got to make certain that you understand what's being asked of you and answer that question. So my suggestion is that when you're asked a question, that you take a beat, think about what's being asked, and make sure you understand it first of all. The defense attorney, the other attorney, has to ask questions that make sense. It's their job to make certain that they ask a clear question and that you can answer it. Also, make certain that you know the answer to the question. Again, when you're in that setting and somebody asks you a question, sometimes there's a compulsion to give them an answer, but sometimes the answer is that you don't know. And that's a fine answer as long as that is the answer at trial as well. You should not say at your deposition that you don't know something and then later at trial you're going to talk for 10 minutes about it. You need to be certain when you say that you don't know that you don't know. But I don't know is a perfectly fine answer as long as it's the truth. We need to be cognizant, first of all, did they ask a question that you understand? If you understand it, do you know the answer? If you know the answer, then answer the question and only the question. Don't go on into different areas or discuss things that might have to do with that question. If they want clarification, if the defense attorney wants clarification, they need to ask more questions. Along that same line, don't try to outsmart the defense attorney. Don't try to trick them or parse their questions or make things difficult for them. They are an advocate and a professional talker, and they are going to win that contest. You simply listen to the question, make sure you understand the question, and then answer the question to the best of your ability, honestly. As far as your demeanor goes, you need to be pleasant to the extent that you can. You don't want to be argumentative. You don't want to be angry. You don't want to be short or curt. You want to answer the questions to the extent that you can stay in a good frame of mind and in a good mood. That would be ideal. The best thing that's going to happen for us, and the worst thing that happens for the defense attorney, is that they leave this deposition saying, well, that was a nice person. That's what we hope happens, is they leave and they say, well, I think that a jury's going to like that person. I liked that person. I believed what they said. And that's what I'm going to report to my client, the insurance company, is that when we go to trial, this person's going to do a good job on the stand. They're likable, they're honest, they're forthright, and they're going to give a good accounting for themselves at trial. That's the best result for us and the worst result for them. If, however, the defense attorney is combative or is aggressive, you should leave that to your attorney to deal with. If they try to goad you, some attorneys think that's what you need to do in a deposition, is to push the person that you're deposing and learn whether or not they can. You can upset them to the point where they'll make a mistake, or they'll say something or come across to the jury as an angry, bitter person. So don't take the bait. If there's a fight to be fought, let your attorney fight that fight. You just answer the questions as well as you can, as completely as you can, and as honestly as you can. On the other hand, please understand that the defense attorney is not your friend. I spoke a moment ago about how they might try to push and prod you a little bit. Much more common is for a defense attorney to be very affable, very friendly, and try to get you to talk in a conversational way with them. And maybe you'll say some things that you really shouldn't say, or you'll go too far. Just remember, again, we want to answer the question that's put to you and then allow them to ask other questions if they have questions. But that's not your buddy. You're not making a friend here. You need to keep in mind that this is a formal legal deposition, and you need to answer the questions as truthfully as you can. Most times, the defense attorney and the plaintiff's attorney agree beforehand that any objections to the questions do not need to be stated. We can take them up later on. So if your attorney is not objecting to questions that you think maybe should be objected to, you shouldn't get upset about that. Don't get angry with your attorney. This is not our opportunity to try our case or to present our case to the jury. This is not when we want to talk about our case. This is when we're answering the questions that they're asking. Now, this is an opportunity for them to learn a little bit about you. As I say, it's a discovery deposition, but we don't need to object to the questions, and we don't need to make things hard for the defense attorney or slow things down. We need to go ahead and answer their questions and get it on record and get out of there. Remember, we'll have a chance to depose their client as well under those same rules and those same guidelines and the same structure. Regarding the rules of a discovery deposition, it's frustrating to some plaintiffs a lot of times that they can ask questions that might not seem terribly important to the proceedings. And it's important to understand that there's a different standard at a deposition than there is at trial. At trial, you're not supposed to ask any questions that will elicit any answers that are not relevant. Whereas in a discovery deposition or in interrogatories or requests for production of documents and things like that, you are allowed to ask questions that are reasonably calculated to lead to the discovery of admissible evidence. And that's an important difference from relevance. The questions they ask you don't have to be relevant. They can be reasonably calculated to help them learn something relevant. If someone were to depose me about a back injury, they might ask me how many times I've been married, who I was married to, and how long ago that was. And obviously that has nothing to do with my injury or how my back feels or anything like that. But if they're pressed, they could say, well, I just wanted to have an opportunity to contact his ex-wife from 25 years ago and ask her if he had back problems all the time back then. And that's reasonably calculated to lead to the discovery of admissible evidence, and for that reason, it's an acceptable question at a deposition. So you can expect to hear questions about your education, about your family, about your friends, about where you go to church, about what civic clubs you're in. And yeah, that's not going to come out at trial, but it is something they can ask during a discovery deposition, and you should be willing and happy to answer those questions. As I said, this is a discovery deposition. That means that the defense is discovering more about you. They're going to learn about you as a witness and how you're going to hold yourself and how you're going to give compelling testimony at trial. If you do well in your deposition, and hopefully if you follow these tips, you will do well in your deposition, then that defense attorney is going to go back to his boss, typically the adjuster for the insurance company, and say, well, we got problems here because this person is going to be a likable person at trial. They're going to do a good job with their testimony, and I think a jury is going to award them money. If they feel like that a jury is going to award you money, then they're going to offer more money to settle your case. So a good performance at a deposition can add value, absolutely add value to your case. So at the end of the day, you answer the questions that are put to you as honestly and as pleasantly as you can. Don't rise to the bait. If you're challenged, let your lawyer, and if there are any fights that need to be fought, let your lawyer deal with those, and you just try to have a good time. You're going to be asked questions that you know the answer to, because they're all questions about you. There's no long division here. You'll be asked questions about you and your life and what you've done and your injuries and the accident. You know all these things, and you'll do just fine in your deposition, but we need to make certain that we stay calm and that we answer the questions truthfully.